Okay, everyone, welcome to the ADR presentation for today. It's a CLE and a CME, and I think I know everybody on here, but I can't say your name too often, so I'm Ann Dalton, and we are recording. That's a legal requirement to advise you of that. We record these so that people who do not have the capability of joining us live can review these presentations on the Florida Bar website. And I'm sorry, the Florida Bar YouTube site, pardon me. So if you are interested in other presentations we've done, please feel free to check out the YouTube channel for the for the Lee County Bar. One of those days, for the Lee County Bar, and see if there's something there that will be of interest to you. We also have a couple of more ADR CLE presentations coming up. The newest one will be in April, and that is on interpersonal violence, and the subject matter will be human trafficking. So I think that's going to be very exciting. And then we're having an elder mediation presentation in March. So please mark your calendars. I've sent out some information. But today we have Teresa Daniels doing a fantastic presentation on Social Security issues that that we all need to probably get more information on. Teresa is a Florida native. She's been practicing law here in Lee County for 10 years. Before earning her law degree, she founded the Disability Advocates in Fort Myers. As a non-attorney claimant representative, she helped countless people all over Florida receive their Social Security disability benefits. Teresa's solo practice is called Daniels Law, and it is a well-rounded family law practice providing assistance with divorce, custody, adoptions, Social Security disability, and probate administration. At this time, I'm turning it over to Teresa. And Teresa, thank you for providing your time and your good thoughts with us today.
Oh, thank you, Ann. I appreciate it. I need to change this to speaker view. Okay, so thank everybody for showing up. Hopefully you're very interested in this topic, and it's not just a sign of the COVID times that we're also bored that you have to listen to me drone on for an hour about Social Security disability. But here we go. I'm going to share my screen. This is just a handout that I have prepared. It's no fancy pictures or anything. This will be available to anyone who wants it. Just shoot me an email. So I have been doing Social Security disability for many, many years, and hopefully I can pass some knowledge on to you that is helpful in your practice areas. Social Security has its own language. You see these acronyms here. Some of them are interchangeable, like SSDI, that is the main Social Security disability insurance. We also call it SSD, DIB, Title II. But these will be interspersed throughout the presentation, and they're just there for your review. So my firm mainly focuses on the disability of helping clients obtain their Social Security disability. So that's where the focus of this presentation lies, but there is a lot of information in here that hopefully will be helpful to you either in mediations or in your own practice or dealing with your own clients. So the two main types of disability programs offered by the Social Security Administration are the SSDI and the SSI. The SSDI, that's the main insurance program where we work, we pay in our taxes, and it is like an insurance premium. And once we've worked long enough that we are covered with enough quarters of coverage, then we are entitled to A, retirement, and B, disability should we need it before our retirement age. It doesn't matter about your assets or income, as it states in here. You can be a millionaire. It's your money. You've worked for it. You're entitled to it as long as you've worked long enough under Social Security for the entitlement program. This comes with Medicare coverage, but Medicare doesn't start until 2 years after your entitlement to the money benefits. The other program is SSI. It has the same medical requirements, except it's not tied to your past income. It is tied to your present financial state, whether your assets can only be a certain amount and your income has to be below a certain level. And for 2021, the monthly benefit rate for SSI is $794 a month. It is possible to get both of these benefits if your SSDI benefit amount is below the $794, or actually $20 above that, then you may be entitled for SSI as well. And as long as you get at least $1 in SSI benefits, then you're also entitled to Medicaid. which is very important. When you get SSDI, there's a 5-month waiting period before you're entitled to money benefits. So you have to be disabled for 5 full months before Social Security will start paying you. A lot of times people don't even apply until much later, and you have to be careful about that because Social Security will only pay you back 1 year prior to when you filed for the SSDI. And for SSI, they pay you starting the month after your application is filed. So timing is important. You can start losing benefits, or your clients can start losing benefits if they wait too long to file their applications. For the SSDI program, I'm going to go back a page. They do pay benefits to your back a page. They do pay benefits to your dependents if you are receiving SSDI benefits, children under the age of 18, and spouses that are staying home to care for a child who's under the age of 16. And just like in divorce law, if your child is still in school at 18, they can continue receiving benefits until they graduate from high school. Once you reach full retirement age, these benefits convert automatically to your retirement benefits. There's not a change in the benefit amount. It's just a designation of the actual benefit. For SSI, again, that's a financial need-based program. If you apply for SSI, that's considered an application for all benefits to which you might be entitled. So you can't just apply for SSI and say, I don't want to touch my SSDI. It doesn't work that way because they're going to make you take from what you've already paid in over the federal benefit program because it's a welfare type program. Also for the SSDI, under that comes a disabled adult child program. That program is for people who become disabled before they turn 22, but don't have enough of a work record, either no work record or a very limited work record, to get benefits on their own or to get high benefits on their own. And then if they have a parent who's entitled, who's either disabled, retired, or deceased, then they can apply on that parent's record and get benefits, as long as they can prove they became disabled before they're 22. I just did one now where the claimant was in his 40s, but his dad just became eligible. So we just got him disabled adult child benefits. Covered all of that. Disability. So Social Security, they have a very simple but strict definition of disability. You have to prove to them that you have an impairment that is expected to last for, or expected to keep you off work from at least 12 months, for at least 12 months, or to result in your death. It doesn't mean you have to wait 12 months to apply, but a lot of times that initial denial that is so infamous will be because it hasn't been 12 months and Social Security is going to say, well, you're going to get better, so we're not going to pay you. You can also apply for a closed period. So if you were off work for 12 months because of your disability, but you've gone back to work and you want to apply, you can apply for a retro for what's called a closed period. So keep that in mind as well. Substantial gainful activity, that is a dollar amount that Social Security comes up with to say, hey, if you can earn this much money a month, then you're not disabled. They don't care if you're working in McDonald's or if you're an attorney, what you're used to making. They care what you are making. So even though you may be working 5 hours a month as an attorney, if you're earning $1,310 a month, then they'll say you're not disabled, you're able to work. And that's the first question in their 5-step determination process is, are you presently working? And if you are working, working full-time and earning SGA, they are going to deny your application right off the bat. So if you're not working, is it because you have a medical impairment? And if you do have a medical impairment, is it severe? So something like high cholesterol is not going to be a severe impairment because you're not having symptoms from that generally. But if you've lost your leg or the ability to stand or walk for very long, then that is severe. Social Security has a list, it's a book of medical listings where they define certain impairments and they list what requirements that they need or documentation that they need to show that you meet these listings. So that's the next step in the 5-step process. If you meet the listing and you have the documentation, then you're going to be approved, and you can usually be approved right at the initial level. about 30% of claims are actually approved at the initial level. If your condition does not meet a listing, you might argue that it actually equals a listing. So, well, maybe I can stand for 4 hours a day, but I can't deal with people because of my stress or something like that. And so the combination of these things actually equals this listing, even if I can't meet it. That's generally difficult to prove, but it is part of Social Security's regulations that they do have to look at that. The next step is, can you do your past work? So Social Security will look at your work history for your past 15 years and look at your impairments that you have now and limitations and see if you're able to do that job. They actually, if you end up at a hearing, you're going to have a vocational expert attend your hearing who's going to testify to those things. And they also look at the next step. Can you do any other work? So a VE's job at a hearing is to, one, identify your past work and any transferable skills you might have from that work, and to determine, based on hypotheticals given by the administrative law judge, if the claimant can perform, or a person similar to the claimant can perform the claimant's past work. If they can, then that's a denial there. Then the judge usually gives 3 hypotheticals where they get more strict as they go on. But then the vocational expert, if it says no, the claimant can't do their past work, then they look to see, is there other work that exists in significant numbers in the national economy that this person can do with the impairments given by the judge? And generally, the vocational experts will find some work. And I have seen button sorters or bobbin sorters. The easiest job that they come up with, or in the past have come up with, is a surveillance system monitor, where the person just has to sit and they have the option to sit and stand and monitor surveillance cameras. And so you have to be able to show that you can't do that type of work, depending on several things. So once you reach the age of 50, it becomes a little easier to get Social Security disability. As you can see, Social Security starts thinking, oh, they're getting old now, which I'm kind of offended by, because now I'm up in the advanced age category and that hurts my feelings. But there are some grids, and the grids take into consideration a person's age, education, and past work history, and whether or not they have transferable skills. And that's what the vocational expert has to use as well. When you become age 50, or certainly advanced age, then, like I say, it gets easier. When you're advanced age, you pretty much have to show, or the judge has to show, Social Security has to show, that any job that you can transfer to has to essentially be the same job that you're already doing, just less strenuous or less stressful. So like I say, once you get older, it gets easier. I've listed here the education categories Social Security considers. As far as work history, again, it's the past 15 years, and you have to have done the job long enough to have learned how to do it. They're not going to look at a job that someone's only done for 2 weeks or even 2 months. They have to have worked long enough to learn it and have earned substantial gainful activity from that job for Social Security to consider it. So generally, you have to show that you can't perform your easiest job that you've had. There's a list here of severe impairments. They have physical and mental. Social Security has to consider everything, but you can't take, say you file a claim because you haven't been able to use your shoulder and you have a backache, and that doesn't quite get you Social Security. And then later on, okay, well, now you've hurt your ankle permanently, and now that combination makes you disabled. Social Security is not going to go back to the time when you initially filed for just your arm and your back. If that wasn't enough, they're going to say, okay, when you hurt your leg, that's the time you're disabled enough that we consider you permanently disabled. And they also have to look at both physical and mental. So it's the combination of impairments. Does that combination prevent a person from being able to do a full range of work? Talked about having to be insured. So you get a quarter of coverage for every so many dollars that you pay into the Social Security system. And you generally have to have 40 quarters of coverage to be covered for retirement, and then for Social Security disability, generally you have to have worked 5 out of the last 10 years to be insured for disability. So if you're younger, you don't need quite as many quarters. They have a table for that on ssa.gov if that's something you need to look at. And then again, the disabled adult child disability before age 22. They can't be married at the time they apply unless they were married in the past and divorced. I have gotten benefits for someone who had been previously married, but because she had never received her disabled adult child benefits before, they went ahead and approved her claim, even though she had been married in the past. It's getting more and more difficult for to get claims approved at the Social Security Administration because of, well, as you can imagine, Social Security is rumored to be going broke and they're just tightening up on everything. So Social Security is more and more looking for objective findings to document disability. And, there's a list of some here and non-exertional things as well. The doctor's opinions are important. We generally send questionnaires to our doctors with specific questions geared toward what Social Security is looking for. Social Security historically has not given any weight to opinions of chiropractors or licensed mental health therapists. I think that's wrong, especially when we have specialists like neurologists sending our clients to chiropractors for care, but that's what we're dealing with. So if you are screening someone to see if they might be eligible for disability, here's some things that you look for. So first, look at their age. Are they under age 50? And if they are, then their impairment has to be pretty severe. They have to prove they can't do any type of job whatsoever, any type of sit-down job on a full-time basis in order to get disability benefits. And if they are still working, are they working full-time or part-time? And how much are they earning per month? If they're only working part-time and they're earning under the substantial gainful activity amount, you need to make sure that they're working those limited hours based on their impairments because they just can't do anymore. For example, they might work 3 hours a day and then it take them a day and a half to recover before they can come back to work again. Especially if it's a physical thing like backache, they might be bedridden for a day after they work, but they're still trying to make some income. So it's not true that you can't work at all. You just have to be under that SGA level and your income has to be limited due to your impairment. Obviously, they can't just say, well, I want to stay under this amount so I don't lose my Social Security. Another type of income that usually is over the SGA amount that we argue is called sheltered employment. So if a claimant has a family member that's giving them a job and paying them more money than they're actually worth for the work they're actually performing. If anything, they may just have them on the books and them not working at all. So you have to show that yes, they were making money, but it's sheltered employment. It's not real work. So Social Security can go ahead and approve the claim. If the person is over 50, usually my ears perk up a little more. I listen, for why it is that they might be disabled, and usually they have a pretty good claim. But if they're just telling you, well, I look for a job, but I can't find a job, or no one's going to hire me because, I'm old or whatever, my skin is purple with pink polka dots, whatever it is, that's not enough for me. I want to know, why will no one hire them? Will they not hire them just because they're not hiring? Or are they not hiring this person because they have poor work record? What's happened in the past to keep this person from being able to get a job or hold a job? And sometimes I might get the employment records to show that a person has missed a lot of work. So yes, they were working, but they had to call off work a lot, or they got reprimanded for poor performance a lot, those types of things. So just really question the why as to a person isn't working. And then you have the one that's still working that calls you and says, well, I'm working, but I really can't work. Well, yeah, you can, you are, but I can't work. So we have to go through that whole discussion. So again, just kind of screen them for where they might fit in the process, if they're a legitimate disability or if they just don't want to work. So attorney fees are set by Social Security. It's a contingent fee. If there's no past due benefit, then there's no fee. It's 25% of the claimant's past due benefits, which are calculated from the time that they should have been receiving benefits until Social Security says, hey, we give up, you're disabled, we're going to pay you now. and the attorney gets paid based on the start date through the date before the favorable decision. And the cap is $6,000. Some attorneys can apply for higher fees. I do not do that. My fees are capped at the $6,000. I have done some that I know are going to get approved right away, and I know there aren't going to be any past due benefits, and just ask the people to just, hey, send me a referral or give me a good review or something, because it doesn't take much of my time to do that, especially since I have a Social Security paralegal who does all that for me. So yeah, you could also ask for benefits for, if there are no past due benefits, you can ask for filing a fee petition with the Social Security Administration. It has to be approved by the judge. I don't like doing that because you don't always get what you ask for. You may think you're entitled to $1,000, but I've had a judge come back and give me $350 on a case that I spent hours and hours on. And then the person, this was before direct fee payment for me, and that person didn't pay me. So or actually they had, because there were no past due benefits, that's what happened. There was nothing for Social Security to withhold, and I had to go after the claimant for the benefits, and they didn't pay the $350. Expenses are separate. Up until through the initial and reconsideration level, Social Security will gather the medical records for the person at no cost to the claimant. But once it reaches a hearing level, then the onus becomes the claimant's to make sure that the record is complete. And that's when our firm would start gathering medical records and having to put out-of-pocket expenses. I used to ask for a small cost deposit. I don't do that any longer. I figure that, hey, people are broke when they get to me. They've gone months or years without anything eating up their savings, so I'm not going to kick them while they're down. And then when their claim is over, if they're approved, I send them a bill for the expenses. Generally, the ones that are approved pay, the ones that are not don't, and it all comes out in the wash. So the process. So you file your initial application online, or your representative does that for you, and it can take 2 to 4 months to get a decision. But here are the steps that it takes. The local office prepares the packet, sends it up to a disability determinations office, which is a state agency. They gather medical records. They may send the claimant out for doctor appointment for evaluations, medical evaluations, if their medical record isn't sufficient enough. And also they will send out questionnaires both to the claimant themselves and to third parties who know the claimant. These questions, the one is a functional capacity, or not functional capacity, but just a functional questionnaire. What do you do all day? What can you do? How long can you sit, stand, walk, whatever? What chores do you do? How long do you do them? And then they'll ask a third party the same questions. Have you noticed, what changes have you noticed? How long can this person sit, stand, walk? Other questionnaires that might come out would be, say, if you're alleging a cardiac condition, there'll be a cardiac questionnaire. If you're alleging pain, there'll be a pain questionnaire, those types of things. Our office helps out with all those. So if our clients get these forms, they can be overwhelming. And that's our job, is to take this overwhelm off of these clients who are suffering physically and mentally, and doing the work for them. So we just ask them, give us a call, set up a time with Courtney, my assistant, and she will go over these forms with you. She will fill them out and file them on your behalf. You just have to talk you through it. They still have to spend a little time, but they don't have to do all the writing and all that. So that helps. If you're denied at the initial level, then the next step is a request for reconsideration. It is the same exact process as the initial. If there are no new medical records, then it might be a very quick denial. You might get one within 2 weeks. Otherwise, it's again another 2 to 4 months. As I mentioned earlier, the initial application, normally around 30% are approved at that level. The request for reconsideration, only 10 or 11% are approved at that level. After the request for reconsideration denial, next we're asking for a hearing before an administrative law judge. There was a time in Lee County where it was taking us 2 years to get hearings. Now we're looking at 6 to 8 months once we request the hearing. So that has improved significantly. Part of that was because we started having remote hearings from judges, with judges from other states to help us with our backlog. And we went from 2 judges to, I think, 7 now, 5 or 7 in the Fort Myers office. So that was very helpful. So at the hearing stage, again, we have to make sure that all of our medical records are in. and that we get it. Usually we do a pre-hearing brief, just an outline for the judge. We submit it before the hearing. So we tell them what we think the issues are and why they should approve it. Obviously, you all know what briefs are, but it's very helpful for the judge. And then at the hearing itself, the judge will do the basic introduction. Some judges will do all the questioning and then let the representative follow up. Some judges just turn it over to the representative and they do the follow-up questions. But it's just really, the questions are along the line of all the things we've just talked about. You don't have to go through the past work because that's in your record and the vocational expert's going to do that. But how do your impairments affect you and your ability to work? So we go over all those things: sitting, standing, walking. How much is this person resting? Do they require a lot of breaks? Are they able to deal with people, authority, bosses, clients? Are they able to leave their house? A lot of them have that, where it's just too stressful to even go to the grocery store. If you're denied at hearing level, there is another level with the Social Security Administration. Is their appeals council. You have to submit to them another brief saying why you think the judge messed up in their decision. If your request for review of your hearing decision is approved, you just go back to the same judge for a new hearing. Very, very rarely do they say, okay, we're just going to grant your request now. They make you go back for a new hearing. But at least you know what you're looking, what the appeals council is looking for on your end and on the judge's end, so you can hone your hearing, your new hearing, to those issues. The next step would be a federal appeal. I don't do those any longer. There are several firms in town that do. I used to do them, but I just chose not to anymore. It's all paperwork, no hearings at all, and that is a lengthy process. If you had an SSI claim denied and you file a request with the appeals council, if you have new evidence, they will, if you need to file a new claim afterwards, if your request for a review of hearing decision is denied and you need to file the new claim afterwards, they will let you retroactively file an SSI claim to the date after your, to the date you filed your appeal, or going back anyway. You don't have to say, we're going to lose all these benefits for the time you were waiting for your decision. The federal appeal, and also if you've got a claim pending with the appeals council, you can't file a new claim until you get a decision from them. All right, looking at issues for family law, going a little more to what a lot of us do. So be aware that if a child is getting SSI benefits, those benefits are the child's benefits. They do not count as income to the parent when you're calculating child support. It doesn't go to the parent's income. And also be aware that Social Security will take part of the SSI benefits if the child is receiving child support. And I've got a calculation on the next page. So they don't count the first, so for SSI purposes, Social Security does not count the first $20 of income. And then they don't count 1/3 of the child support amount. So here I used an example where the SSI benefit was $600. And I think the rate for 220, the average child support payment in 2020 was $435 approximately. So you've got your original benefit of $600, and then you're taking your child support minus 1/3 they don't count, minus the $20 they don't count, and you're left with $270 of countable income from the child support. So the new SSI benefit for this child is $330. Then you add that to the $435 in child support. So they're now getting $765 a month. That's a huge chunk out of their SSI benefit. But again, it is a welfare type program, and Social Security is going to make sure that you're not getting more, or they're going to try to make sure you're not getting, you're not benefiting, basically double dipping. I did have a note here that the SSI benefit for 2021 is $794. And the reason I use $600 for the child is because for child's benefits, the Social Security Administration looks at household income. So they will look at the income of the parents when determining the child's benefit amount for the month. And then getting back to what I said a minute ago, when you're doing child support calculations, you don't count the child's SSI payment. That's his income. If one of the parents is receiving SSDI, you do count the dependent benefit is income to that disabled parent. And if that parent's obligated to pay child support, then you offset the child support with that dependent amount. If the dependent amount from Social Security is less than the child support obligation, the disabled parent does have to pay the difference. If it is more, then it covers all the child support, but you cannot count that income you can't count the overage as income to the other parent because that benefit belongs to the child. There is case law on that. If anybody needs it, let me know. I give that to you. Miscellaneous. I'm going fast. All right. If a person is incarcerated, they are not entitled to benefits during that period. Usually for SSI, they just have to start all over when they get out. For SSDI, there is an accelerated reinstatement process. I don't do those things, but it is available depending on how long you've been without benefits. Disability insurance benefits can be garnished for family support, restitution, taxes, and other federal obligations. SSI benefits cannot be garnished. Unless there's been an overpayment of SSI benefits, there are no other situations in which SSI can be garnished, not taxes, not student loans, not anything. Cash settlements for SSI, and this is where an elder law attorney would need to be consulted if your person getting SSI is for old age SSI and not for disability. But cash settlements, like a personal injury claim, that will affect your SSI benefit because, again, they look at your income and assets when determining your benefit amount. If a single individual has more than $2,000 in countable assets, then they are not entitled to disability benefits strictly because of their financial situation. So if you know you're going to get an SSI or some kind of settlement through an attorney, ask that you don't be paid until the very first of the month. And then you've got 30 days to spend that down appropriately on things that SSI considers, like paying down your mortgage or buying a vehicle or medical equipment, things like that. It has to be an approved type. You can't just go on a Disney vacation and say, I don't have it anymore. But you do have 30 days to spend that down. So again, ask that you get paid at the beginning of the month. So you've got a full month to spend that down and get your bank account back into under the $2,000 range. You could also, again, this is more for the SSI old age, but there's a special needs trust or a Medicaid trust that can be made. I don't do those. I don't know a lot about them, but you can have a trust created, again, to protect assets so that your SSI benefits will continue. That's important when you've got an older person in a nursing home. And I know just enough about that to be dangerous, so don't ask me. Workers' compensation, Judge Weiss would probably know more about this. I see he's on here. They do affect your Social Security benefits if you're waiting on a past due payment and monthly payments, and vice versa. Whichever one you get first, they affect each other. I don't do that. Again, if you've got that situation, certainly talk to your workers' comp attorney about that. We talked about you could get both benefits at the same time. VA benefits, you can receive VA benefits and still get SSDI benefits. That does not affect entitlement at all. If you have someone who's on benefits and they start working after their benefits or they work a little more, they have to be careful because there's something called a trial work period. If they start earning over $940 a month, which is the amount for this year, Social Security is going to start counting how many months that you're earning that much. And you have 9 months and they don't have to be consecutive months. They look at a 5-year period and it's a rolling period. So any 9 months within a 5-year period, if you make more than the trial work period amount, then Social Security is going to say, okay, then your disability has ended and we're going to stop your payments. So you have to be careful about that. I think that's important for our purposes for family law mediation to know that, hey, my ex has returned to work, so they may be going off a disability soon. Keep an eye out on if they're working part-time or full-time. You may end up being able to go back and get more support if they're paying support. And I have come to the end because I am Speedy Gonzalez. So I would like to open it up to questions. If anyone has any, I'm happy to try and answer them.
Is there any way to determine what a projected disability payment would be for an adult? Like when you have a minor who's receiving Social Security that's going to transition to being an adult. We see this come up regularly when somebody wants to make a claim for permanent child support for a disabled child. And we know that it's going to impact their Social Security, but we don't really know how to determine how much it may affect it at all.
So that's strictly the SSI program. So all children's benefits are SSI benefits if it's based on the child's disability. So once they turn 18, now they have to meet the adult disability rules. There's a listing, there are listings for child impairments and listings for adult impairments, and they have to meet the new rules for the adult. And if they're going to continue on, and like you say, get the child support continuing after 18, that's just going to depend on what their living situation is. Now, Social Security is not going to count household income so much, but if they're still living at home and mom's paying, or dad or whoever's paying room and board, then they may deem that as income to the child and reduce their benefits. So you're going to start at that $794 amount, which is the maximum for 2021. And you may just have to file the application and let them do the, do the financial interview to find out. If this child is receiving benefits on a disabled parent or deceased or retired parent's record, then that again is going to stop when I honestly don't know, Tony. I think it was Tony who asked if that particular benefit, the disabled or the dependent benefits, would continue on if the child is disabled. I don't know. Dependent benefits. I don't know about that one. But as far as the SSI, no, you're going to start with that base amount, and then you're going to have Social Security do the financial screening to see what other income might be. And then you're going to go back to this child support chart that we talked about, and where they're going to count 2/3 of that minus $20 as income to the child.
I guess my question is will they do the financial screening like on a scenario basis? That's what I was thinking. Like, hey, if this much is paid, what will that do? I guess that's always a question, it seems like.
Well, if you know what the benefit amount's going to be, like I say, you're just going to have to start with that $794. And then if you know what the child support's going to be, then you can deduct from there. But just be aware that it may be reduced if they're still living at home. I have the exact same situation, but the child is living on his own with support from mom going over there. They're not, but they're not living at home anymore. So they get the full benefit amount minus the income for the child support. So it just depends on the child's situation. I don't know if they will tell you, Tony, without actually filing an application.
Thanks.
Teresa, is there a Florida bar number assigned to this webinar as yet?
There is, I don't know it, but I would get with Lauren.
That's actually my question. Not to jump in. I was eating lunch, which is why I didn't want anybody seeing me chew. I went off video. What happens is that the Lbaugh submits the application to the Florida. Lbaugh submits the application to the Florida bar, and then there's a bit of a delay. It used to be a couple months, and now it's down to about 6 weeks. So as soon as Lauren gets Lauren from our bar gets a certificate, she goes ahead and mails it out. And that's why it's important that everybody come in through the Lbaugh site, because that's how she toggles who gets the certificate. So you'll get it, but it's not available at this time.
That's fine. Also, Teresa, can we have access to your notes?
Yes. So anybody who wants those, if you will just shoot me an email. Here's my email address. I will be happy to share this with you.
Excellent. Thank you very much.
Teresa, just out of curiosity, is there an advantage or disadvantage to a general practitioner to practice in this area, or is it such a specialized area that it really makes sense to consult somebody like you for these kinds of questions?
I would suggest that you consult someone who does it You don't have to be an attorney to do Social Security disability. I did it for many years before I went to law school, representing these claimants. But that's what I did. It's all I did. And for lack of a better word, I specialized in that area. And I would definitely recommend that you seek out someone who's familiar with it.
Do you have any opinion about why there's always, not always, but nearly always an initial rejection of the claim?
My theory is that if a person doesn't very clearly meet one of the disability listings that I talked about, then they're going to have to go on into an administrative law judge, because you're dealing with people who aren't judges. You're dealing with these disability determinations office who's just, again, they gather your records and they send it to a doctor who never sees you or examines you, and they just make an opinion based on the records that they have, whether or not they think you can do work, which leads the disability examiner to make a decision, yes or no. And so I'm thinking if your records aren't very clear that you meet one of their listings, there's no one there to argue, say, well, they've also got this and they've also got that, and look at what their limitations do. You know, they're not able to deal with people, or they're not able to sit for more than 2 hours a day without having to take a significant break every, very frequently. There's no one there fighting for you. I mean, we've sent in briefs at these levels, but they just don't get us anywhere unless there's a clear listing of meeting a clear list, clearly meeting a listing. I know what I want to say. So then you have to go before the judge and be able to lay out your entire case.
I know it's difficult to project it, but I'm going to put you in the hot seat.
Okay.
Anyway, you know me. And so do you see any will in Congress to modify any of these laws, or not really?
There are two groups that are very active, the National Association of Disability Representatives and the National Organization of Social Security Claimant Representatives, NOSCOR and NADER, and they are all the time lobbying for changes and things. So is there anything on the horizon? I couldn't tell you at this time. I'm happy to look that up if you're really interested. I think we had a question down here, Mr. Pritt.
Yes, I guess a couple of them. Did I hear you say you only do disability?
I don't only do disability, but that is one of my practice areas. That's what I've done the longest.
Okay, we have a lot of retirees down here. I count myself as one of them recently. And I will say that my wife and I probably get some type of a determination at least every 2 weeks with a different number on it as to what we're entitled to. And a couple of times we just went ahead and appealed, and then they actually made the changes. I find I did a little bit of Social Security work. I don't know if you're familiar with the Amish waiver, but there is a large Amish community in Sarasota. Most people know that. And a lot of them are out of Ohio, and I actually went up to Akron, Ohio, and did a hearing. But the issues as to what somebody is entitled to, and this is not disability now, but retirement benefits and so on, it's pretty Byzantine to try to get through all of that. And it would seem to me, and I'm not about to do it, but it would seem to me to be a pretty viable practice. And that's why I wondered whether or not you do anything other than disability.
I do not. And the only person I know who does, he's not an attorney, but he is a former Social Security employee. He worked in the local offices processing claims for many, many years. And he's actually local to us. So if anyone is interested, I'm happy to share his name. I met him through the NADR, NADER organization. And he's very knowledgeable there, but I don't know anyone who does it as an attorney.
Bob, what is that Amish exception? I've never heard of that.
Yeah, hardly anybody has, but this goes back to the Kennedy administration when they tried to make Social Security requirements applicable, and the Amish objected to it because it was deemed to be a form of insurance that was against their beliefs. And so the compromise at that time was that they could waive it was almost all men at the time, but they could waive having to pay into Social Security and therefore waive getting anything out of Social Security. The awful thing that happened since then is that just due to changed circumstances, many of them had to take jobs. Back then, they're all farmers, virtually. I mean, a few woodworkers and so on, but then they wound up that they had to get jobs working at restaurants, working at brick factories and places like that, where they had to pay in, but then they could never get it out because of the waiver. And it's a terrible injustice. And I was involved both up in Ohio on that, and then more recently, I had a couple of cases because the people had moved down to Sarasota, were trying to get their benefits. And yeah, that's it in a nutshell. They still don't get the benefits, even though they paid into it in many cases all their lives almost. So,
Oh, gosh.
but those are types of things that somebody who does Social Security for a living, and not the disability, but the ability to get benefits and retirement benefits would be a real big thing down here.
Interesting. Any other questions? Okay, I don't see any. I do want to thank you, Teresa. Great job. I know that all our presenters spent a great deal of time putting these together, and I know specifically Teresa did. So thank you so much with all of your other obligations. Our next ADR CLE coming up is March 18th at noon. It's a presentation by Alexandra Kleinfeld, who is on this call today. And it's regarding elder mediation. And the specific title of her presentation is Knives Out, Elder Mediation versus Family Feud. So Alexandra, I didn't know if you had a minute to talk about it. Not to put you in the hot spot, but.
Oh, that's fine. Yes, I'm pretty sure some of you saw the presentation I recently held at the reptile section. It will be a little bit different for the ADR section, since we are more familiar with the mediation process in this section, so I don't need to inform you about the basics. However, elder mediation is really a great topic to discuss and to learn about, especially since we are living in a community where a lot of people are a little bit older, and family issues may arise due to the fact that we all grow older now in the meantime. And well, families are not necessarily wanting to deal with the changes of getting older. So it's really interesting to see how you may be able to prevent any guardianship cases or any family disputes, and even maybe resolve already existing family disputes by just coming together to the table and talk it out and have everyone heard and have everyone's opinion actually put in together, and have the mediator as the neutral third party to basically observe everything, to guide the family in the right direction, so that they are able to discuss everything without going to the knives and kill each other. So I hope you are able to attend, and I'm looking forward to that.
Thank you. And once again, that is March 18th. These CLEs are free. Of course, they also qualify for CME if you are a mediator. And it is at noon. And once again, it will be via the Zoom platform for everyone's convenience. So, oh, Herb, you had something you wanted to say?
I think it would be, wrong for us not to acknowledge your work in getting all this together, and we really appreciate it. And also, I did want to say that the Florida Bar, the YouTube, you mentioned the Florida Bar YouTubes, they're amazing how much stuff they cover and all the various factors, so that should be looked into. And my third hint is, third thing is, when you press the space bar, you can talk, and you take your finger off the space bar, it's off. It's very easy. But thanks again, Ann, for your work today.
I didn't know that, and I appreciate that. Thank you very much. Well, folks, it's 6:01. I think we're done for today. And I know, Teresa, you've done a fabulous job, as always. And we are terminating at this time. Thank you.
Thank you.